Today we're going to talk about putting your kid, your son or your daughter's name on bank accounts, your house, or anything like that. I'm Michael Redden. If you have any comments or questions about this subject, please put them down below. If you'd like to talk with me or plan, then go ahead and click the link in the description and schedule an appointment, or go to reddenlawoffice.com and click on schedule a planning session. So don't put your kid's name on your bank accounts. A lot of us think that, hey, I'm getting older, I might need some help. I'm just going to go ahead and put my son's name on the deed, put my daughter's name on the bank account, and these other kinds of things. Now, we got to be careful how we do that. You can add them as a signer on your bank account, and if you're just putting them on there as a signer, that's totally different than making them part owner. But if you go ahead and put your kid's name on your deed, or put your kid's name as actually an owner on the bank account, you're actually making a gift to them. You may not realize that, but that's an actual gift. And they are now part owner. If you've given them more than $15,000, $30,000 if you're a couple, you now have to file a gift tax return. That kind of affects things when it comes down to your overall estate tax exemption later on. Additionally, now those individuals have access to the money, and so do their creditors. If they've got any kind of problems with things, such as bills or things being late, or even if they get divorced, that piece or whatever that you gave them is now subject to the divorce estate and being split up. So it's really is not a good idea from an asset protection standpoint, and it's not a good idea from an estate planning standpoint. If you need someone to be able to just take care of those things, that's what a financial power of attorney is for. And that's what the Minnesota statutory short form power of attorney is all about. You're going to give that to the bank. The bank will then know that person can make decisions on the account and do signers, do those kinds of things. If you insist on doing this, make sure they're a signer, not a joint owner. Still make them to pay on death so they get it when you pass away, but don't make them a joint owner. That makes them own half of what's in there, and it makes really hard things happen if there was going to be a divorce, if there was going to be any kind of creditor issue, determining what's theirs and what's yours, and it just puts those things at risk. Now, the same thing happens for your home. If they get a judgment against them, now they've got a lien on that property, and you are still trying to live in that property with all that equity, and now there's a big lien on it, and you may have paid that off free and clear. Put a transfer on death deed on there to make them be your beneficiary and get it when you pass away, but don't do that. Another thing is, as we get older, we might think to do this, and it can complicate our long-term care planning. If we put them on there, there was a gift, okay? We made a gift because we weren't paid for it, and they were kind of put on these accounts. If you ever need any kind of assistance with your nursing home bills, then when you go to apply for that medical assistance, there's going to be that question on there: have you made any gifts in the last 5 years? That's a gift. You're going to have to say yes. And that's going to affect your benefits and when you can actually get them. And it will cause you to be denied at first because you made a gift that was uncompensated. So it's going to be bad for your long-term care planning. It's going to be bad for your estate taxes. You're going to possibly have a late gift tax return. It's bad for asset protection because there's going to be opening up to divorce and other things that your child or your spouse might encounter. And it's a real simple way to take care of this. Just get a transfer on death deed and give them a statutory short form power of attorney for your finances, and then they can do those things if they need it. It's a lot less complicated than doing all these other kinds of risks. So when you're thinking about putting your son or daughter's name on the title to your house or anything else, remember these kinds of things. If you're going to put them in a bank account, make sure they're a signer, not an owner. All the other things, it's hard to put their name on there without making them be an owner, and that opens up these other things. It's best to just put them as the beneficiary and get that short form power of attorney. If you have any questions or comments about this, please put them below. If you'd like to talk to me, click on the link and set up an appointment.